this panel is going to be focusing on global animal law, recognizing that we as a country exist as part of a greater world. Of course, we are looking at a new animal law in South Africa, but according to the Constitution, when we look at the Bill of Rights, when interpreting it, we must consider international law. It's a requirement, and we may consider foreign law. So there's actually a very clear directive as to what international law means in our society. This is why it's important. Another reason it's important is because we consider ourselves as a progressive society in South Africa. But if you start to look around the world, you'll realize that we actually are not that progressive. I also want to clear up some comments from yesterday. There was a statement that other countries haven't recognized animal rights. That's completely false. Many countries around the world have explicitly recognized animal rights. They've also recognized rights for nature. And I think it's important for us to take an outer perspective and look in as we plan this process. So I'm not going to preempt our speakers. We have a wonderful panel. These are them. A few of them are joining us online. Unfortunately, they couldn't be here in person. We have Dr. Tracy in person, and Dr. Macarena Montez is a pre-recorded session. So that one, we're not going to watch the entire one, but we are going to share the links with everyone to watch. Also, just in case there's tech problems like yesterday. But we do have Dr. Masika Sophie joining us online and Dr. Dafe Erikefe. So our first speaker is Dr. Masika Sophie. She is the Global Health Manager at the World Federation for Animals, where she leads high-level policy engagement with the World Health Organization on the Pandemic Treaty, the United Nations General Assembly on the Political Declaration of Antimicrobial Resistance, and the United Nations Environmental Programme, UNEP, on the nexus of health and the triple planetary crisis. She serves as a steering committee of the Quad Tripartite-led AMR multi-stakeholder partnership platform, try saying that a few times fast, and leads a global action group focused on the intersection between AMR and animal welfare. Dr. Masika is also an advisory committee member of the Alliance for Human and Animal Coexistence and e-trainer with the Food and Agricultural Organization on Women's Leadership in One Health, and an alumna in the Gates Women Lift Health Leadership Fellowship. In her earlier career, she served as the Chief Veterinary Officer with Kenya's Ministry of Agriculture, an epidemiologist in the National COVID-19 Preparedness and Response Task Force, and a researcher on zoonotic viruses in wild primates at the Institute of Primate Research, with additional work in wildlife conservation. So she's really well qualified to talk to us about what's happening on the international stage, and we're very excited to hear your presentation. So without further ado, I'm going to allow you want to share your own screen?
Thank you, Amy. Let me see if I'm able to share. I think you're supposed to allow me.
Great.
Okay, looks.
Wonderful. Thanks.
Can you confirm that you see my slides?
Yes, perfect. Please proceed. Thanks.
Okay, thank you, Amy, for the great introduction. And because I know we are behind on time, I'll just go straight to, I will talk about 5 key international policy processes that have recently happened within the last year, are currently happening, and things that we should be looking out in terms of animal health, animal welfare, but in the larger policy, global policy space. So I will start with the UNGA, which is the United Nations General Assembly Political Declaration on AMR. This was adopted last year in September at the UN in New York, and this was necessitated by a meeting that was held in 2016 that identified that antimicrobial resistance requires a One Health approach to tackle it, so involving human health, animal health, and the environment health. Now, specifically on this declaration, which was adopted by all the UN member states, it recognizes the need for One Health approach, a need for multi-sectoral coordination, but most importantly for animal health, there are commitments for member states to reduce the use of antimicrobials within the agri-food systems, including animal health, by 30% by 2030 from the current level. But it also recognizes for that to be reduced, there needs to be strengthening of animal health and animal welfare systems within at the country level. Now, two of the most important commitments from this political declaration that I'm going to talk about today is this. So the first one is the formation of an independent panel for evidence for action against antimicrobial resistance. This is one of the commitments that the UN mandated the quadripartite agencies. And when I say quadripartite throughout this presentation, I'm referring to the World Health Organization, the Food and Agriculture Organization, the United Nations Environmental Programme, and the World Organization for Animal Health. So they were mandated to form a panel of experts who would come together and bring together evidence on AMR. And this is because evidence on AMR is very scattered, it's segregated. In different regions, there's very little evidence on what is going on, and specifically for us within the African region. This is really important because our AMR is a wicked problem. It affects all the three sectors, and there needs to be more consolidation of the evidence that AMR is impacting the continent the most, as most of the other global crises does. The second thing, so we're working on that this year, and we hope to have a panel by the end of this year in December. The second thing is a review of the Global Action Plan for Prevention and Containment of AMR. We have had a global action plan that all member states, by now, I think 90% of all countries have already adopted it into their national action plans. And I believe South Africa has a second version of their national action plan for AMR. Now, this review process is important for animal health and animal welfare because the first draft was not very strong on the animal health component, because at the beginning, AMR was mostly seen as a human health problem. But for the current review that the process is starting today, we aim to include strongly the animal health component, animal welfare component, because especially for animal welfare, it's a preventative approach rather than a reactive approach, which is mostly what the Global Action Plan, the initial one, was all about. Now, I will go to the second international policy process, which is a pandemic agreement. We have been negotiating for a pandemic treaty for the last 3 years. And this was brought about by COVID-19 pandemic, where the WHO member state decided that we need an agreement to make sure that we are protecting the world against the next pandemic. So initially, we had not determined whether it's an agreement, it's a treaty, it's a political declaration, but as of now, we know it's a treaty. Now, a treaty, what is a treaty? You may all know, but for now, a treaty is a contract that is agreed upon by two parties, and in this case, all the member states or the WHO member states. This is agreed upon through a negotiation process. So we've gone through 19 formal negotiation processes with many other informal processes. And when I say 19, one negotiation process takes a week at the minimum, and every day it's from 8 a.m. to midnight, or even further every day. So it's been a very intense process to make sure that we have an agreement. So as of this month, we have text that is already agreed upon by all member states, and we hope to adopt the treaty during the World Health Assembly in 2 weeks. Now, in the treaty, there are two really strong articles that touch on animal health and animal welfare. And the first one is we have a whole article on One Health. Now, this article on One Health is really important for the animal health sector because for the first time, we have One Health in a legally binding treaty. We have animal health and animal welfare recognized in a legally binding treaty. So all member states who will sign or ratify this treaty will be required to ensure that there are certain, the health systems, the animal health systems, animal welfare is up to a certain standard. But this will not be done alone. There will be the fact that we have a legally binding treaty, it means there's going to be support, especially for countries from the low and middle income countries, will get a lot of support in terms of technical guidance, knowledge dissemination, best practices, and any other support that these countries will require to get to a certain level where it's on the same level according to the guidance document. The second thing that this means is there's going to be regional coordination to make sure that what South Africa is doing, your neighboring country is also doing the same, because we know diseases do not know borders. So we need to make sure that our systems are unified. Then the second article that is also important is the article on prevention, which is Article 5. And this is important for animal health because it is specifically talking about prevention of pandemics at source. What does that mean? It means that member states will prevent the root cause of the problem. We know most of the zoonotic viruses, most pandemics originate from animals or originate from wildlife specifically. This is mostly important for Africa because we are one of the continents that lives very closely with animals, both livestock and wild animals. So if we are able to center prevention in pandemics, it means we are protecting our communities, are protecting our livestock. We are making sure that our wildlife is also protected in the same sense. Now, the third process that I will talk about is the United Nations Environmental Assembly Resolution. And this was adopted in 2022. And this resolution recognizes that animal welfare and animal health and the environment are linked together with sustainable development. And most importantly, they're linked to the health and well-being of human health. So this was a really groundbreaking resolution adoption, especially in the environmental space, where it's been very difficult to move anything that is not environmental specific or environmental related. So the declaration asked that the UNEP, together with the coordinated agencies, come together, bring together finding and create a report to show that truly there is a nexus between animal welfare, animal health, the environment, sustainable development, and human health and well-being. So far since 2022, we have had from the UNEP side, there's been a couple of processes that have gone on to creating a scoping study report. So far, as of end of last year in December, we have a scoping study report that has started explaining the linkages between animal health, environment, and sustainable development. And some of the areas that this scoping study highlights is as a linkage or the nexus is on sustainable food systems, both in aquatic and terrestrial, ecosystem management, earth resources, and they're looking at animals here as a form of resource, especially for countries which mainly depend on livestock or wildlife as a form of livelihoods. There's also global mandates, because these linkages create also an additional need to understand where does it link with other multilateral processes. It also looks at the economics and trade. Like I said, there's livelihoods, especially for Africa when you talk about animals and wildlife. But it also talks about the role of animals in water provision, in agriculture, in industry, in livelihoods, and this specifically touches on working animals. Now, I think this is the fourth international policy process, is on biodiversity and health. And specifically, I'll talk about the Global Action Plan for Biodiversity. This was adopted last year in Cali during the Convention of Biological Diversity. And this Global Action Plan specifically recognizes that animals play a key role in food production and in zoonotic disease emergence, prevention, and preparedness. So with a Global Action Plan being adopted during the CBD, it means countries now are currently working to adopt the global action plans into their national action plans. Now, what we have an opportunity to do, or what we are currently doing, is to provide guidance documents or tools and resources for countries to efficiently adopt the global action plan into their country-specific context for their national action plans, and making sure that animals are very well featured in their role on biodiversity conservation, preservation, and all that. So as of now, we are working with a number of countries to come up with tools, resources, capacity building materials, stakeholder engagement, and other policy integration case studies and best practices for the adoption of the Global Action Plan. And the very last policy process I'll talk about is on sustainable development. We all know we have the SDGs and we have a goal for attaining them by 2030. Now, every year we have a process that reviews the Sustainable Development Agenda. And the process is a high-level political forum, HLPF. This year, SDG 3, which is on good health and well-being, is under review. Every year, there's a set of SDGs that are reviewed every year. But this year, SDG 3 is really important to us. And this is because we are also aligning with other multilateral processes that I've mentioned that have specifically elevated the role of animals and the role of animal health and animal welfare within the international global policy space. So for us, SDG 3 is important because during the first review of SDG 3, which happened a couple of years ago, antimicrobial resistance was already included as one of the measuring factors. So this year, we already have a political declaration that, the UNGA political declaration that recognizes AMR requiring a One Health approach. So we want to integrate animal health within SDG 3 a bit more strongly. We also are bringing in the aspect of zoonotic diseases when it comes to good health and well-being for both humans and animals. And we are also linking health to climate change because, the health of humans, animals, and the environment are very much impacted by climate change. Yeah, so I think that is the end. I know I've gone through it very fast because we're short on time, but I'd be happy to take any questions regarding any of the policy processes. And back to you, Amy.
Yes. Hi, sorry, I'm just turning on the speaker. Can you hear me?
Yes, I can hear you.
Wonderful. Thank you so much. That was a really informative and excellent presentation. And please stay in for questions, which we'll do at the end. Great. So I'm just going to share the screen for our next speaker. It's the wrong one. One second. Great. Thank you. So our next speaker is Irakefe Dafe. He is a leading environmental advocate, scholar, and practitioner dedicated to advancing Earth-centered governance. Since 1992, he has been deeply involved in the protection and restoration of the River Ethiopia, championing its recognition as a legal entity. His work has contributed to the establishment of multiple environmental institutes across Nigerian universities, fostering education and research in ecological law, climate policy, and ocean protection. Dafe serves as the Africa Program Lead for the Earth Law Center in the USA, and he's also a member of the United Nations Harmony in Nature Program and the Global Alliance for the Rights of Nature, playing a pivotal role in shaping global and regional discourse on Earth jurisprudence. Irakefe holds a postgraduate diploma in environmental science, a master's degree in environmental policy and regulations, and is a PhD candidate specializing in rights of nature and ecological law. He has authored several books, and he is really a wonderful colleague that I work together with at the Global Alliance for the Rights of Nature African Hub. So it's my pleasure to introduce you, Dafe, and looking forward to your presentation. Are you there? There we go.
Thank you. Thank you for having me. Good morning, everybody from Nigeria. It's my pleasure to be with you in this very important colloquium being organized by Hemi. Congratulations for putting this together. My topic is short. I will go through it very well and very fast. When I got the invitation on this seminar, what really struck my mind was that what is the sense of a right of animal where he lives, the habitat does not have a right, because just one single human activity can actually wipe away multiple species of animals in a particular habitat. And that informed my topic on this seminar, Why Protecting Animal Habitat Matters. So I will just go straight to the main topics and speak briefly on them. The points are just simple. A growing recognition of animal as a sentient being is no longer new, and we are aware that's why we're in this meeting. And we're also seeing a situation where there's a shift from welfare to right-based approach, and the urgent need to protect habitat as a key animal survivors. And talk about the intersection of law, science, ethics, and ecology. So as a way of introduction, the global discourse on environmental and ecological justice has increasingly recognized animals as a more than mere resources for human use. The emergence and evolution of global animal law and policy represent a shift toward the ethical and legal consideration of animals as a sentient being with its value. While laws vary across country and region, a unified theme has emerged: the protection of animal habitat as a fundamental cornerstone of animal welfare, conservation, and ecological stabilities. So let's look at evolution of global animal laws and policy across the world. Animals law, once relegated to the margin of legal thought, has gained traction over the last few decades. From the Universal Declaration of Animal Welfare proposed at the United Nations to regional frameworks such as the EU Animal Welfare Strategy and national law like the Animal Welfare Act, USA, and Prevention of Cruelty to Animals Act in India, there has been a progressive integration of animal protection within legal system. More recently, the concept of political law and the right of nature movement has further challenged anthropocentric paradigms by promoting legal rights of non-human life and ecosystem. Globally, we have witnessed the recognition of animal sentience in several jurisdictions, e.g. New Zealand, the EU, Chile, and the UK. The banning of animal testing for cosmetic in over 40 countries. The illegal recognition of greater apes and certain marine animals has legal entity in court cases. The development of international animal law institute and networks such as the Global Animal Law Project and the Animal Law Section of the International Bar Associations. Despite this advance, element of animal law. So why protect animal habitats? That's the big question we should ask. One, interconnectedness of species and an ecosystem. Animals do exist in isolations. Their well-being is intrinsically tied to the health of their habitats. Forests, rivers, wetlands, savanna, oceans, and coral reefs serve as a homes, breeding ground, and migratory routes. The destruction or degradation of this habitat through deforestation, mining, urbanization, and agriculture, pollution leads directly to the displacement, endangerment, and extinction of these animals. The other reason why protecting animal habitat is biodiversity conservation. Protecting animal habitat preserves biodiversity. Biodiversity is not only crucial for ecological balance, but also essential for ecosystem services such as pollination, pest control, and climate regulations. Legal framework that integrate habitat protection help reduce this loss of species and maintain ecological resilience. The other reason is combating zoonotic disease. Just like my last speaker highlighted in his remarks, scientific research has been shown that habitat destruction increases human-wildlife contacts, facilitating the spillover of zoonotic diseases, e.g. COVID-19, Ebola, SARS. Strengthening habitat protection law, therefore, is not only about animal welfare, but also about public health and global biosecurity. The other reason why we should protect animal habitat also include climate change mitigation and adaptation. Nature Natural habitats such as forests, peatland, ocean are vital carbon sink. Their destruction contributes significantly to greenhouse gases emission. Conversely, protecting this habitat helps mitigate climate change and support animal ability to adapt to changing environmental conditions or situations. And culturally and ethical consideration. Many indigenous and local communities have long recognized animals and their habitat as sacred, forming the basis of their spiritual and ecological knowledge system. Incorporating traditional ecological law into modern animal laws and habitat policy can enrich legal framework and enhance conservation outcomes. So let's talk about the progressive legal approach to habitat protections. One, legal personal for ecosystem. The recognition of rivers, forests, and mountains are legal entities which with enforceable rights, e.g., Wanganu River in New Zealand, Atrato River in Colombia, offer a promising model for linking animal and habitat. And here in Nigeria, we are working so hard to make the River Ethiopia as one of the first rivers in Africa to be recognized as a legal entity. We recognize that once this is achieved, the animals and all the other species that reside within River Ethiopia or that see River Ethiopia as a homes will be protected. So protecting River Ethiopia not actually for the sake of the water, but also for the sake of the living things that see River Ethiopia as a home. The other reason for that progress for legal approach to habitat protection also includes ecocide law, proposed as a fifth international crime under the Rome status. Ecocide will criminalize large-scale environmental destruction, including habitat laws that impact animal populations, habitat corridor and landscape level planning. These are the progress that are going on. Legal policy that facilitates habitat corridor across fragmented landscape are essential for migratory species and wide-ranging animals like elephant, tiger, and wolves. One health and one welfare framework. This integrated approach promotes the simultaneous well-being of people, animal, and the environment through coordinated laws and policy, just as my last speaker highlighted here. Where challenges and opportunities, what we are here for today. While the legal architecture is growing, several challenges persist. One, lack of enforcement and political will in many parts of the world. Weak coordination between environment, agriculture, and animal welfare laws. Insufficient funding for habitat protection programs in many parts of the world. Economic pressure driving habitat destruction, e.g. industrial agriculture and mining. However, the ongoing global awareness of climate change, biodiversity loss, and animal science provide an unprecedented momentum. The post-2020 global biodiversity framework, the sustainable development goal, and the emergence of climate mitigation all provide entry point for embedding animal habitat protection into national international legal framework. Conclusion and way forward. Protecting animal habitat is not only a matter of conservation, but a profound legal, ethical, and ecological imperative. The progressive development of animal law must move beyond the narrow confine of antiquated status to embrace holistic policy that protect animals within the context of their natural homes. This requires international cooperation, the incorporation of indigenous knowledge system, stronger environmental justice framework, and unwavering commitment to the right of all life forms. Only by securing the habitat that sustains them can we ensure the dignity, survival, and flourishing of animals, and by extension, the planet itself. Thank you for your attention.
Wonderful. Thank you so much, Stafe, for the call to action and the really interesting presentation about rights of nature around the world. Great. Please stay on for questions at the end. Our next speaker is Dr. Tracy Kanyanga. Sorry, I'm going to skip to your slides. Wonderful. Okay, so Dr. Tracy Kanyanga holds an LLB, an LLM, and an LLD, the trifecta, hey? She is a postdoctoral research fellow at the South African Institute for Advanced Constitutional, Public, Human Rights, and International Law, SAIFAC, at the University of Johannesburg. Her research focuses on environmental law, the intersections of human rights and climate change and climate justice. She has published on climate change and its impacts on vulnerable groups, including animals. And Tracy's also been helping us with our book on South African animal law and welfare. So welcome, Tracy. No, you're fine. It's blocking the, is that fine? You look beautiful. Can I use your phone?
Morning, everyone. I would like to thank Daphne and Sophie who spoke before me, and I would like to thank them for priming what I'm about to say. It's kind of related, but different in its own different way. So yeah, when you're speaking, you fear that whatever that you're going to say, okay, your fear is like what you say is at least comprehended and grasped by the audience. So if for anything, you're not going to remember anything that I said here, remember this quotation that I wrote here. So Justice Copeland and Prof yesterday talk about the interconnectedness, right? But I just want to reiterate that concept and speak about the interconnectedness of everything, right? So when I was writing this paper, so this is a paper, and what I'm presenting is extracts from my paper. So when I was writing the paper, I had a sense that sometimes as human, we forget that we are interconnected, not just as human beings, but we are connected to the plants, to the animals, to the rivers, to the forest. That's what makes us humans. That's what makes us who we are. So in this quote, so when I was writing, I was trying to bring out that notion, right? So the notion that humans exist is separate from non-human animals and the environment is reductive. It diminishes the intricate interdependence that define our shared existence. Such a perspective overlooks the profound interconnectedness between humans, animals, and the ecosystem we inhabit. Recognizing this interconnectedness is essential as it underscores the reality that the well-being of humans is intrinsically linked to the health of animals and the environment. So after coming up with this notion, I began to ask myself, what does the law say about this? What I've just said. So does the law view humans and animals and the environment as interconnected or as separate, each protected for its intrinsic value? So as human beings, we all know we all possess rights, including the right to life, health, a safe and a healthy environment, to name just but a few rights. But the concept of right becomes more complex when applied to animals or non-human entities such as animals, forests, and trees. However, the legal landscape is gradually evolving with growing recognition of the intrinsic value of nature and the potential for extending legal rights or protections to non-human beings. So what does domestic law say about this? So there is recent, there are global trends, right? So under domestic laws, there is recent legal research that proves that there is a recognition of animals' rights, as Amy alluded to earlier on. So this is recognized through constitutional approaches and judicial approaches as well. So courts in countries like Argentina and Pakistan have treated animals as right holders. So in Argentina, in that particular case over there, the court recognized a chimpanzee named Cecilia as a non-human person and a subject of rights with the cognitive ability of a 4-year-old. And then in Pakistan, again, in the name of the case highlighted there, if anyone wants to go and read the case, the court declared that animals are subject of rights and recognized that an elephant named Kavan was not property and ordered his release from the zoo to a sanctuary. And then on constitutional developments, Several states such as Australia, Brazil, and in Africa, Egypt, have incorporated animal protection provisions into their constitutions. The Egyptian constitution, Article 45, states that the state shall protect the seas, the shores, lakes, waterways, and natural reserves. The state shall also protect and develop the country's animals, fish, and plants resources. We'll argue about the term resources afterwards because something came to my mind when I was reading that, but I cannot go into it right now. So while not directly a right charter for animals, this clause has been interpreted by Egyptian activists to support strong protections for animals. And as we know from what we heard yesterday, here in South Africa, while animals do not have constitutional rights, courts and scholars like Prof. Gilchrist, Amy, and Melanie, who was here yesterday, are increasingly framing animal interest in right-based terms. This signals an emerging thought, this signals an emerging thought of entrenched rights discourse. Notably, also, I'm not sure, I wasn't here, I was in and out, but I'm sure this case was highlighted yesterday, the NPCA case versus Minister of Agriculture of 2013. The Constitutional Court affirmed the intrinsic value of sentience of animals, a significant step towards a right-based approach. But then now, whilst we see the domestic arena embracing what we term animal rights, right? I found out that in the international arena, it's not the same. In international law, they speak more of animal welfare as opposed to animal rights, right? So that's why I'm saying this movement of animal rights is not fully extended into the international legal arena, as there is no binding global agreement granting animal rights, right? Rights are different from welfare. But whilst that is the case, we have the World Organization for Animal Health. I think the first speaker alluded to this earlier on, which has developed a welfare standard, right, for animals, but they are inconsistent in their implementation across member states, resulting in uneven animal protection. So to address this gap, there were also some scholars that came up with a global treaty, the International Convention for the Protection of Animals, right? My slides went back to the beginning. Okay, yeah, that aims to establish global guidance for animal treatment. And then there have been several proposals aiming to establish global guidelines for animal treatment, such as the United Nations Convention on Animal Health and Protection, drafted by the Global Animal Law Association for consideration by the United Nations, right? So while animals currently lack explicit claimable rights under international law, these proposed treaties that I highlighted in here, they signal a shift for future recognition of animal rights. But then what do we do as international law scholars in the international arena when we don't have a binding treaty as yet? So in the meantime, international environmental law instruments, such as those protecting biodiversity, climate change, can be interpreted to indirectly support animal protection. So what am I saying in all this? So I'm saying in the absence of legal rights or a binding treaty at an international platform, so what do? We become very creative, right? So whether a legal norm confers an unwritten right on animals, it becomes a matter of interpretation. You know, lawyers like to interpret everything, right? To their advantage most of the time. So that is the game they play. So they'll be like, okay, fine, let's take environmental law treaties and let's protect animals using those. So in that context, many scholars, including I myself, have been able to utilize what we term the systematic interpretation as a strategy to interpret the right to a healthy environment, which includes environmental concepts that have got implications on animal rights. So the right to a healthy environment is for you and me. It's a human right. It's got nothing to do with animals, right? So that's what I'm saying. Environment rights, it entails any proclamation of human rights to an environmental condition of a specified quality and includes various substantive and procedural rights. As you can see from my diagram there, what the right to a healthy environment entails. So a little background on the right to a healthy environment. So in the international arena, the right has not been recognized yet under the instruments like the UDHR or the ICSRC or the ICC, which is the binding international human rights instruments. However, in July 2022, the United General Assembly adopted a resolution recognizing the right to a clean, healthy, and sustainable environment. Though not, remember I said it's the United General Assembly resolution. So though not legally binding, the resolution carries symbolic and normative weight, influencing the environment of international law. So some scholars even argue that the right to a healthy environment, which is first and foremost primarily a human right, has emerged under customary law, right? And in addition, it has been widely adopted at national and regional level. So the fact that it hasn't been adopted at an international law, at an international level, well, it's not very that much important because we can see the customary law emergence of the right, and many nations and regional treaties have got provisions for these rights. For an example, our own South African Constitution in Section 24, it talks about the right to an environment. So now I'm like, okay, fine. So at a superficial level, the right that is meant for you and me, it appears anthropocentric, right? Because it entitles you and I to a healthy environment conducive for our own well-being. However, the right can be interpreted, like I said, to be more inclusive, extending protection to animals, right? So to protect animals and nature. So now when we think of nature, Amy earlier on alluded to rights of nature, right? So in Ecuador became the first domestic jurisdiction to recognize rights of nature in its constitution. Other jurisdictions followed, granting entities such as rivers and forest rights. And then in Africa, I did the research to find out whether we have any country that has got a provision on rights of nature, and I only found it in Ghana, right? And then Ghana recognized the ecosystems as right-bearing entities. And then the government is required to protect and conserve and restore the ecosystems, right? So perhaps what was interesting for me in this oral research was how the scope, or rather the notion of rights of nature has evolved to embrace animals. So in 2022, the Constitutional Court of Ecuador, in the case of Estrelita the monkey, they recognize that animal rights constitute a specific dimension of the rights of nature with its own particularities, meaning animal well-being could be recognized through rights of nature. So whilst animals could be recognized through the concepts of right of nature, as I alluded to earlier, they can also be recognized through our own right to a healthy environment, which includes concepts that have been spoken to earlier, I think by Daphne, the concept of biodiversity and ecosystems, right? But then when you now look at it from an environmental perspective, we are now talking about a healthy biodiversity and a healthy ecosystem. And then for you now to situate animal protection or animal rights within our own human right to a healthy environment, this is the strategy that I use, which is the systematic interpretation. I'm not sure if most of you are interested to hear the nitty-gritties of this, so I'll move along to what's more important to you guys. So which is the healthy biodiversity, right? So international law, specifically environmental law, protects biodiversity through treaties like the SAIFAC, and then the Convention on Biological Diversity. And instruments like the UNFCCC and the Paris Agreement also indirectly support biodiversity whilst they are addressing issues of climate change. So the CBD is the most relevant international treaty in this context that aims to advance the conservation of biological diversity and sustainable use of its components, amongst other objectives. Article 2, which I will not reiterate, highlighted there, states that there should be a variability amongst living organisms, such as animals from all sources, including the land, marine, and other aquatic ecosystems. So put differently, just basically means there should be a varied different species living on land, oceans, and the seas. So the above definition does not specifically highlight animals, right? But in its simple form, a biological community abounding in living organisms such as plants, trees, algae, insects, and animals, right, is considered a healthy biodiversity. So that's how you can interpret the animal protections into our own right to a healthy environment. And then I did the same thing when I was looking into issues of a healthy ecosystem. But let me dial it back a little bit. So in the end, I found that when we try to use a human right to protect animals, it's 15 minutes.
Yeah.
Can I just wind up with
Yes,
something?
of course.
Yeah. Okay. So when you try to protect the rights to, when you try to protect animals using human rights, there is a danger in that. Fine, it introduces noteworthy innovation, such as protecting animals. But as you would realize, the rights talk, rather, it doesn't really fully encompass animals, because animals in this regard are viewed as an ancillary to us humans, right? So I started to think, okay, fine. So how can we give animals stronger protections within the legal landscape that we have? And I found this case, which is a 2017 case by the Inter-American Court on Human Rights Advisory Opinion. It was just basically talking about the rights of the environment, claiming that the environment in itself is it was defining the environmental right as an autonomous right, which protects components like forests, rivers, and seas, and as legal interests in themselves. But when they defined the issues of nature and environment in the environment components, I realized that the environment components that they had provided for within the advisory opinion were not only exclusive to the entities that they had mentioned, which is the rivers and seas. It could be expanded also to include animals. So this recognition, or this particular advisory opinion, would therefore give stronger protection to animals. And then, okay, so now I just wind up. I'll just wind up by going back to my first slide. If you do not remember anything that I have said, just remember this. Thank you very much.
Wonderful. Thanks so much, Tracy. That's really informative. I think it's important for us to understand what's happening in international law. I'm going to summarize some key themes at the end, but I want to just introduce our next speaker, who's actually done a pre-recorded video for us, which I hope is going to work properly. But I'm also going to just pop it in the chat for the online attendees, because yesterday we had some issues with the screen sharing. Michaela Chesen, can you just drop the link to the Macarena's video, please? Thanks. All right, give me 1 second. No, it's fine. I'm trying to find the. Okay, well, in the meantime, as we get the link into the chat, I'm just going to introduce Macarena. So Dr. Macarena Montes is a Rights of Nature Fellow at the Brooks McCormack Jr. Animal Law and Policy Program at Harvard Law School. She holds a PhD in law from the University in Barcelona, and she has been a visiting researcher at the Max Planck Institute for Comparative Law and International Law at Heidelberg, as well as a rights research fellow at Harvard Law School. She is a board member of the UPF Center for Animal Ethics. She's an editor of the Journal of Law, Ethics and Philosophy, a member of the editorial committee of Animal Ethics Review and Chilean Journal of Animal Law, and a treasurer of the Great Ape Project in Spain. She's written several articles on non-human animal personhood, animal rights, and the rights of nature, as well as a book entitled Animal Law in Chile. So she has a lot of really excellent expertise, and I'm going to cut the presentation short just because it is quite long, but I hope that those in the chat will return back to it afterwards. And Macarena is really going to talk a bit about what's happening in other countries and the progressions that have been made for animals there. So if you can't hear the sound for the online attendees, please play it on your own computer just in case it doesn't work. Thanks very much.
Hi, everybody. My name is Macarena Montes, and I'm really happy to be participating, though I'm sending in a video because I'm in the US. So the time difference was too much to participate virtually. Today, I'll be talking about certain cases in Latin America on animal rights. So I'm going to start and share my screen, my presentation with all of you. Okay. I hope you can see it. Okay, so my name, as I said, is Macarena Montes. I'm a Rights of Nature Fellow at the Brooks McCormick Jr. Animal Law and Policy Program at Harvard Law School. And my research focuses on animal personhood, animal rights, and the rights of nature. So around the world, there are cases on animal rights in different regions, but in Latin America, it's the region in the world where we can find more cases. As you can see in this map, most of the cases are from Argentina. The US is marked on this map because of the Non-Human Rights Project's cases. We also have several cases in Brazil, some in India, Ecuador, Colombia. And so, as we can see, with the years, more and more cases have been filed arguing for animal rights, and the strategies to argue for these rights have been different. Today, we're going to focus on some of the cases from Latin America that will show you that the Global South is a leader in recognizing animal rights and also rights of nature. So today, I'll talk about 5 categories of cases. We will see that some cases are symbolic, then we'll see the habeas corpus cases that follow the Non-Human Rights Project strategy. Then we'll see some cases that use constitutional actions or remedies to argue for the rights of animals. We will also see some cases where judges recognize animals as subjects of rights or rights holders in criminal law cases. And then I'll spend a little more time on the rights of nature cases, because these are quite interesting and unique. So when I started doing my research on animal rights cases and personhood cases globally, the first case I found was a case from 1972 from Brazil. And in this case, a group of advocates filed a habeas corpus to the High Court and argued that all birds that were caged in the country had the right to freedom of flight. And the habeas corpus was not granted, but the interesting thing is that actually this case was used as a metaphor to protest against the dictatorship that exists in Brazil at that time. So we can see how in this case, they were using the metaphor of encaged birds and the right to freedom of flight to argue for freedom of humans. Not in Latin America, but some of the Indian cases on animal rights, we could say that are may be part of the symbolic category of cases where they have this, for example, language of all animals in the animal kingdom have rights. And so they aren't really enforceable, but they are still useful. These symbolic cases are still useful to bring these cases to the public and to judges to start making this connection between habeas corpus or confinement with fundamental rights. So this was the first case in Brazil on a habeas corpus for animals that I have been able to track from 1972. Then, following the Non-Human Rights Project strategy in Latin America, we can also find several habeas corpus cases. And one interesting case is from 2005. This is chimpanzee Suiza in the photograph. And Suiza lived alone in the zoo, and public prosecutors filed a habeas corpus on her behalf. And Judge Da Cruz granted the state 72 hours to present their arguments. And then the state asked for an extension, and so the judge gave them another 72 hours. The thing is that the day the court was supposed to decide this case, Suiza was found dead in her cage. So the judge, in his judgment, in the decision, he said that he was surprised because he had visited the zoo the week before and Suiza seemed healthy, but that even though he couldn't grant the habeas corpus because she had died, he still thought that this case had pushed things forward in Brazil for animals and for the discussion of if they have the right to habeas corpus, if they have other fundamental rights. The sad thing is that NGOs informed that the zoo killed Suiza, and what is alarming is that she was killed to stop her recognition as a non-human person. So this makes us wonder and question what we are willing to do to maintain humans in this supremacy role of uniqueness, of special, of being these special kinds of beings, and we are not willing to give up this this unique position we've been in throughout history. After this habeas corpus, the first successful habeas corpus for an animal was filed in Argentina. This is chimp Cecilia. She lived in deplorable conditions in the Mendoza Zoo. She lived in a barren cement cage. She was mostly alone throughout her life. And the judge recognized Cecilia as a non-human person and as a subject of rights. And the judge managed to transfer Cecilia to a sanctuary for great apes in Brazil. And as you can see in these pictures, this was Cecilia in the zoo. As you can see, the barren cage behind her, her only enrichment was having trees painted on the back of her cage. And this is a picture of Cecilia arriving at the sanctuary. This is the first night. She's looking up at the sky. It's the first time that she's seeing an open sky. It's the first time that she's touching grass under her paws. And this is Cecilia today. Cecilia will never be forced to be alone again. At the sanctuary, she lives with Marcelino and Miguel, other chimpanzees. So she has her small group. And this sanctuary is run by a man who's part of the Great Ape Project. So he believes, and the sanctuary works as a place where great apes are treated as non-human persons. So animals get to decide what they're going to eat, what their hobbies are, who they spend time with, where they go inside the sanctuary. And so all of this change, because for Cecilia, this case actually did change her life and for the better, was thanks to a judge who was brave enough to grant a habeas corpus in 2016. So now let's move on to other constitutional actions. So some of you may know who this is, or maybe not. This is Sandra the orangutan, And she was also kept in a zoo, but in a different city. She was kept in a zoo in Buenos Aires, the capital of Argentina. And this case started as a habeas corpus, but eventually the advocates decided to file a different type of action, a constitutional action or constitutional remedy that's available in Argentina, where they argued that Sandra had different fundamental rights. And the lower court, the judge became famous for recognizing Cecilia as a non-human person and as a subject of rights. And after some struggle, the judge also managed to transfer Cecilia to a sanctuary for great apes in Florida, in the US. And Cecilia's case is really important because she became famous. As you can see, these are examples of media, international media, talking about Cecilia. And we can see that the case at the bottom says, gradually, nervously, courts are granting rights to animals. So some say, well, Cecilia was the first non-human person, the first animal to be recognized as a non-human person, and this case ended up with her transfer to a sanctuary. So it was also successful and changed Sandra's life for the better. The interesting thing is Sandra and Cecilia's cases that are coming from cities in Argentina have been used as precedent or as examples or as inspiration for other courts around the world. For example, the case in Pakistan on the Marg Hazard Zoo mentioned these cases as examples of foreign cases on animal rights. So we can see how sometimes cases, even from lower courts on animal rights, are being used or cited as precedent, obviously not binding or mandatory precedent, but as a precedent by courts in different parts of the world who look for these examples from other parts to build up their cases and not come across to their other colleagues or to the legal community within that country as if they're just making up all these topics. So it's interesting to see how these cases have big effects outside their countries. Then we have some in Argentina as well, some criminal law cases. This is interesting because in these cases, judges on their own motion recognize animals as non-human persons or as subjects of rights, kind of to stress the seriousness of the offense. And several of these cases are about dogs, and so the court recognizes dogs as family members, but also non-human persons. And even in one case, in Polly the dog's case, this is Polly in the picture, the judge said that she was the non-human daughter of the human person and that he was her human father. So we can see how non-human personhood is mixing with this interspecies family, and how judges having Cecilia and Sandra's case in this country feel they have more freedom to on their own motion say, like, yes, in this cruelty case, this animal is a non-human person and a subject of rights too. Then the rights of nature cases. So we're gonna focus on Ecuador because in this country we have the first rights of nature animal rights decision, and so you guys can kind of understand, and well, you probably understand as being a country also from the global south, is that Ecuador, as all of the Latin American countries, are based on extractivism, and in the 90s, Chevron Texaco left billions of trash and pollution from years of extracting oil from the Amazon. And it's this disaster, this environmental disaster is called the rainforest Chernobyl. And at that time, people in Ecuador were starting to oppose extractivism when they saw the images of the Amazon, and the indigenous political force was becoming more and more strong and organized. So these are pictures that show what oil extraction implies in the Amazon. As you can see, it implies deforestation, cutting down a big chunk of the forest, and that means destroying the habitat and the homes of many animals and affecting human and non-humans. For example, here we see how it affects oil spills affect humans, non-humans. The picture on the top right, these are frogs. And so there's a huge problem with these extractivist industries. These are pictures of indigenous women who are protesting against extractivism and the oil industry in the Amazon. This is also a similar picture of indigenous women protesting against this industry. And so, to make a long story short, in 2008, Ecuador drafted a new constitution, and they included nature as a subject of rights. As I'm short on time, I won't read this, but as you can see, rights of nature are regulated in Article 71 to 74, and also Article 10, which recognizes nature as a subject of rights. Then, as you can imagine, being a country that has the Amazon and so many tropical forests and the Galapagos, there is a huge problem with the illegal wildlife trade. So in this picture, you can see victims of this trade. The capuchin monkey that is chained at the bottom, she's not dead. She's sedated to remove that chain. She was kept as a pet for many years. And the little monkey on the right is a woolly monkey that's probably the age that Estrellita, the woolly monkey, was when she was taken from the forest. So Estrellita's case started as she was poached when she was around a month old. She lived with humans for 18 years, and the environmental authority one day received a report that from probably a neighbor saying, hey, there's a monkey living next door. So the authority came and confiscated Estrellita and put her in quarantine in a zoo because Ecuadorian law prohibits individuals from keeping wildlife. So the thing is that Estrellita died 1 month later in the zoo. The family, before knowing this, they filed a habeas corpus to get Estrellita back. But the lower court and the Court of Appeals dismissed the case, and they argued that the keeping Estrellita was unlawful, so they couldn't be asking for her return. But the Constitutional Court selected the case because they were interested in answering this question of the relationship between rights of nature and animal rights, because this court had been deciding several rights of nature case and deciding in favor of nature. So the court asked, can an animal be considered as a subject of rights? What is the scope of the writ of habeas corpus? And can non-human animals be considered as subjects of rights protected by the rights of nature? I co-authored an amicus with Professor Kristen Still from Harvard, and also with Stephen Wise and Kevin Schneider from the Non-Human Rights Project. And we answered, yes, animals are subjects of rights. The habeas can be appropriate for animals. And we argued that animals are protected by the rights of nature. And we gave different arguments to support these statements. And you can find our amicus online, as well as a translation of the Estrellita decision. So really shortly, the ruling said pretty much they used all our arguments, so it was a huge success. They recognized that animals are subjects of rights. The court recognized animal sentience. The court recognized that individual animals are protected by the rights of nature, and this is huge because rights of nature and environmental law usually just care about animals as species. So as the court did this means that in Ecuador, animals have constitutional rights through the rights of nature, which is also a huge tool for advocates in the country. And the court also said that the habeas could be appropriate for animals, but in this case, it wasn't because Estrellita had died. Obviously, as you can imagine, rulings aren't perfect. And in this case, the slippery slope and getting judges to vote in favor of the case means that there are political conversations happening behind the scenes where the judge that wrote the judgment or the ruling is trying to write a judgment that the other judges will support. So the court said that humans are predators, and so that humans can continue eating animals, and that eating animals wouldn't violate the rights of nature. But I'm not going to spend much time on that. I have an article that's been published recently in the Stanford environmental law journal where you can read about that. But what I want to tell you guys is that this case has had some positive effects. So first, the court ordered Congress to pass a bill on animal rights, which is being debated. And as you can imagine, the livestock industry presented a competing bill because, you know, they got nervous about having a bill on animal rights. And then this Trita case has been cited in a case regarding a sloth, in a case regarding dogs and cats. And also, we can see that this argument of rights of nature and animal rights having some sort of relationship, we can find it in another case that recently happened in Peru. A lower court recognized that animals are protected by the rights of nature, and this case was about a fox. So there are positive effects. What other cases do we have? In the case of Panama, we can see, so we already saw what a court can do with rights of nature and animal rights. Now, what can the legislator do? So in Panama, in 2022, they passed a law recognizing the rights of nature. And this law paved the path for a law establishing the conservation and protection of marine turtles in Panama in 2023. The interesting thing is that this law in Article 2 says that the state recognizes that the conservation of marine turtle species and their habitat is of public interest and essential to guarantee the right to a healthy environment for all inhabitants. This law then links the human right to a healthy environment to animal protection. And then in Article 29, the court stated, the law states that the state will guarantee that natural and legal persons protect the rights of marine turtles and their habitats, such as living and having free passage in a healthy environment, free of pollution and other anthropocentric impacts that cause physical and health damage, such as climate change, pollution, bycatch, coastal development, and unregulated tourism. So the law recognizes turtles' right to a healthy environment. And that's important to get us to this point of the presentation, and I'm almost finishing with this, is that, so what can we do if we don't have a rights of nature provision in our country? Because most countries don't. And it's interesting because Panama now does have rights of nature provisions, but they also talk about the human right to a healthy environment in those laws. So first, it's important to look at human rights. And which human rights could we use to argue for interconnectedness, to argue that humans cannot survive without animals and the environment, that these three are interconnected? So we have, for example, the right to life, and this was an argument in the Markhasar case from Pakistan. We have the right to health, and even internationally with the One Health approach, we can see this argument of interconnection. And also, we have the right to a healthy environment. And the right to a healthy environment is interesting because in the case of Panama, they were recognizing the marine turtles have this right to a healthy environment. But we can also say that we can secure the right to a healthy environment for humans if we're not securing that right for animals as well. There can't be a healthy environment without animals. And that could mean from just protecting animals, or it could mean recognizing animal welfare and trying to ensure and protect that, or it can mean also recognizing rights. I think that rights is the destination because rights would actually allow a stronger protection for animals. But also, what else can we use in our legal system? So animal welfare sometimes is seen as like the opposite to animal rights and kind of like a dirty word. But animal welfare can be useful to get us closer to animal rights, or even to get us closer to the practical results of animal rights that would be to free animals from exploitation. So, for example, around the world, many zoos have decided to stop housing elephants and move them to sanctuaries because a zoo, even the best zoo in the world, will never be able to ensure animal welfare regulations for elephants. And this argument, there's scientific research on this where scientists say elephants will never do well in zoos. There's scientific research on this for great apes. For example, right now I'm remembering an article about chimpanzees that says that chimpanzees always have mental problems in zoos. So we see how we could use animal welfare in this sense. Then there are cases, for example, in Brazil, there are cases that where advocates file a habeas corpus, but also behind the scenes, they were pushing to get the zoo to close because it was violating the animal welfare regulation. And then, which is interesting and I think very important because it applies to South Africa, is how can we link animal welfare with human rights? And we could do this with the right to a healthy environment. So this is just to kind of give an idea of like, okay, in some countries, we may have a rights of nature provision. Some countries, we may have judges that are more open to recognizing animals as subjects of rights or as non-human persons. But in other countries, we don't have either of these options. So what can we use? And we can use animal welfare to free animals from industries that exploit them. We can use human rights to try to create an interconnection where animals are included. And so with this, I've reached the end of my presentation. Thank you so much. This is my email. If you have any questions or if you're interested in any of the articles I mentioned or studies, I'd be happy to share them. Thank you so much for inviting me to this, and I hope I can visit South Africa in person one day. So yeah, thank you so much.